Good morning, everybody, and welcome. Welcome. It's a very cold day here in England, in the UK. Welcome to this IEEP UK webinar on the new-ish Environmental Crime Directive and what we've titled a diverging approach with the UK. My name is Michael Nicholson. I'm Head of Environmental Policy at the Institute for European Environmental Policy UK. Now, today we're going to be talking about the EU's Environmental Crime Directive, but we're going to do this and frame this within the prism of EU UK divergence in environmental law and policy. Here at IEEP UK, we've been running a long-running programme looking at this issue of divergence post-Brexit. For example, we've been examining issues around the Industrial Emissions Directive, around biodiversity targets, sewage and the Urban Wastewater Treatment Directive, environmental data and reporting. We're going to be talking more about air quality this year and on circular economy, for example. But we've also been talking about intra-UK environmental law and policy. So, for example, we're going to be looking more at agricultural policy now that our four nations and the UK as a whole is outside of the common agricultural policy. So look out for a report from us on that later this year. Now, I'm delighted to be joined by several eminent and distinguished guests and experts in this field, and I'm going to be passing over to Professor Richard Macrory in a moment. But before I do, I'd just like to say a few words about the EU Environmental Crime Directive and this issue of divergence. Now, as many of you probably already know, environmental crimes usually provoke a very strong response from the public, whether it's destruction to nature or oil spills or dead fish in rivers. It often elicits a very visceral response, and this comes out in various public surveys and Eurobarometer surveys and so on. And a lot of environmental crime is often tied up with serious organized crime as well. And it involves other non-environmental crime too, involving horrible things like guns and people trafficking and money laundering. And that makes it particularly difficult to tackle as well. Applying criminal sanctions is often very, very time consuming. It's very expensive, and it's reserved usually for the most serious environmental crimes as well. Now, the EU member states and the European Union as a whole, the EU member states have tended to only use criminal prosecutions in a very small number of cases. They tend to be very small in number. There's a real heavy reliance on administrative sanctions. And this is perhaps a historical development of our separate legal system, something that maybe Richard might want to say more about later. But the European Commission, in coming forward with this directive and now that it's passed, is aimed at trying to gradually change that historical issue. The Environmental Crime Directive, the 2024 directive, replaced an earlier directive in 2008, and this is much deeper and much broader in its aims and objectives. It's far more prescriptive, and it captures many more environmental laws within its scope. It's up from around 8 in the 2008 directive up to 20 environmental laws now. And it also sets out what those level of penalties should be that should be applied in those cases. It also attempts to broaden out and make much clearer several definitions that it had in the earlier directive. Definitions such as what is substantial damage, what is widespread, what is long lasting, ultimately it'll be up to the court perhaps to decide that, but it really tries hard to make more explicit what is meant there. And it really aims to pull countries up around the European Union with regard to minimum, maximum sentencing levels. Now, of course, the UK is outside of the European Union now and is not mandated, of course, to implement the directive. The UK and England in particular already locks up rather a lot of people with regard to environmental crimes in comparison to the EU member states. And fines are comparatively heavy too. In a sense, the European Union member states are playing catch up with the UK in this respect. And that's not necessarily the case with the other issues that we've covered in our divergence series. But don't get me wrong, what I'm not saying here is that we're living in some sort of wonderland, environmental crime-free wonderland here in the UK. That's not what I'm saying. It still happens, of course, and more than we'd like. But our ability to prevent and stop environmental crime and to prosecute it is, of course, limited. The government here in the UK have introduced a water special measures bill in 2024 in relation to England, for example, part of which, and perhaps some might argue, most of which is targeted at the real or perceived failures to comply with water laws by sewerage undertakers. But adequate funding and training of enforcement bodies is also very important, as is providing those mixture of both administrative and criminal tools for all parts of that enforcement chain. Okay, now I'm going to hand over to my colleague, and I'm absolutely delighted that Professor Richard Macrory is joining us, and he's going to give the keynote speech. And then once he's done that, then I'm going to hand over to my colleague, Chiara Antonelli, who's going to chair our panel discussion. So over to you, Richard.
Okay, thank you very much. Well, let me start with a disclaimer. Last summer, I'd served my 3-year term as a non-executive director of the Office for Environmental Protection, and I'd assumed by now I'd no longer be on the board, but I am still in post. OEP hasn't addressed this crime directive as such directly, but obviously anything I say today is going to be in my personal capacity. Now, were we still in the EU, we would in this seminar no doubt be looking at the fine text of the directive and asking, well, how are we going to implement it within our national system? What are the legal changes needed? But now, of course, as Michael's hinted, there may be clear divergences emerging, and that may or may not be of concern. But I think I might just start that when we look at crime and the environment, I mean, there are already some enormous divergences within the United Kingdom. I do have, and I'll come back to it, a special interest in the role of administrative penalties in any enforcement system. Our legislation, as many will know, actually uses the term civil penalties. The directive talks of administrative penalties, and that's a term actually I prefer, so I will be using that. But if you just look at the UK at the moment, in England and Wales, the environmental regulators have access to administrative penalties, but they have to be able to prove the relevant breach beyond all reasonable doubt, the criminal standard, except possibly for water companies on this new legislation. In Scotland, SEPA has access to administrative penalties, but they are to a much lesser amount, but the breaches only need to be proved on the balance of probabilities. Go over to Northern Ireland, and environmental regulators have no access to administrative penalties, but are wholly reliant on the criminal law. Now, actually, those differences for any academic potentially provide enormous research potential if you want to examine the impact on regulatory compliance and competitive advantage in practice. But I suppose my starting point in this sort of area is, don't just have a picture of a kind of homogenized United Kingdom, which is drifting away from a kind of homogenized or a more homogenized system in the EU. So why should we in the UK consider the new directive? Well, I think there are a number of reasons. First, it forces you to think about some essential characteristics of our own approach to criminal law and the environment. And that in itself may suggest changes that could be valuable in this country, even if not actually required under EU law. But I think in turn, our own experiences may have things to offer the EU, and we'll probably hear a little bit more about the prosecutors network, where the Environment Agency particularly has taken a major part. Now, I'm not going to summarize or go through IEEP's excellent report, and I'll assume that most attendees have either read it or they will be stimulated to do so after the session. But when we think about how in this country we have developed criminal law and its relation to the environment, I think there are some very distinctive features which are not replicated quite in many other countries in Europe. And I'm going to highlight, I think I'm going to highlight 5, which I think are very important. First, we have very little standalone environmental crimes which are not in some way intimately connected with regulatory systems. I mean, we have crimes of disposing of waste or discharging pollutants into rivers, but then the criminal law builds in a defense of acting in accordance with a license or a permit as authorized by the regulator. So the systems are joined up. Now, that is actually not dissimilar to systems in France or Spain or Netherlands, but I think we've gone probably further in providing that nearly every breach of an environmental regulation, including breaches of very minor conditions, are made a criminal offence, whether or not pollution or environmental damage has occurred. And I'll come later then to the question of sanctions, how you deal with that. I think the second important feature of our system is that in England and Wales, not in Scotland or Northern Ireland, but in England and Wales, we have not handed over the responsibility for investigating the prosecution wholly to the police or public prosecutors. In fact, for nearly all environmental offences, any individual or an NGO can actually pursue a private prosecution, even if they've got no direct interest in the matter or have suffered no actual harm, simply just as a citizen, if you like. And this concept of untrammeled prosecution of criminal offences, I think, is unknown in most, if not all, other European countries. And it does happen sometimes, and I've been involved in my early days working for Friends of the Earth and initiating a prosecution under new legislation where neither the police or environmental regulators or anybody else was interested. And also the threat of a private prosecution can actually be enough to put pressure on the public bodies to take action sometimes. And I think that's one of the reasons that in England and Wales, we have long accepted the concept of the regulators, such as the Environment Agency, being able to initiate and undertake their own prosecutions. In contrast, in Scotland and Northern Ireland, prosecutions are undertaken by public prosecutors, with the investigation for environmental offences done normally by the regulators. And I think that's the case in nearly all other European countries, except Ireland, where the Environmental Protection Agency, like our agency, carries out its own prosecutions. Now, it's clearly a system that can potentially lead to abuse, as we saw in the Post Office Horizon inquiry, where the Post Office, and apparently with the chair not even aware that was possible, was undertaking its own prosecutions with kind of reward systems built in and so on. Every so often, there is a call for all prosecutions in England and Wales to be handed over to public prosecutors, as in Scotland and Northern Ireland, but that hasn't happened yet. And then the third sort of very important characteristic, since the early 19th century, we have tended to draft our criminal offences about breaches of regulation or whatever in most areas of law, and not just the environment, in strict liability terms. And this means that a person or a business can commit the criminal offence in, say, discharging waste in breach of a permit, even if there is no evidence of intent or recklessness involved. An unexpected breakdown of a pump, allowing pollutants to discharge into water, that is still strictly a criminal offence. And distinguishing between carelessness, say, or actual intention, really comes at both the initial decision of the regulator to decide how to approach this question, and then also if it goes to court at the sentencing stage. And it's not whether or not the offence has been committed. That's committed, however, whatever the intention is. Now, strict liability for criminal law, I think it's described memorably in a recent study as the last vestiges of medieval morality. It's a concept little known in other European countries. German criminal law, for example, normally requires intention or recklessness. French criminal law is similar, although it does allow strict liability for very minor non-stigmatic violations. Now, I'll come back to this, but I think it's why British judges sometimes, and probably they wouldn't now so much, but they sometimes used to describe strict liability offences as technical breaches of the law and not criminal in the real sense. But as we heard from Michael, in most areas of regulation, not just the environment, but the environment in particular, there are real criminals at work at one end of the spectrum. So it is criminal in the real sense. Now, strict liability is clearly very helpful from the regulator's perspective. Proving intent or recklessness is sometimes, it's very clearly inferred from the nature of the conduct, say deliberate fly tipping, but not always, particularly when factors such as there's equipment breakdown or some misuse involved. It also makes it far easier to convict a company of a criminal offence, because proving intent or recklessness of a company under English law requires the invocation of the so-called identification doctrine. This really means that you have to be able to prove that a person who can be said to be the mind or the will of the company has that degree of intentional recklessness, and then that is transferred to the company. And that means really involving somebody senior. Now, 2 years ago, the Law Commission published an options paper on corporate criminal liability generally, and they noted the complexities involved. And one notable Australian academic said, the doctrine of identification offers little legal certainty, lacks principled foundation, and is based on questionable doctrinal logic. And as the Commission pointed out, that with a smaller company, where the directors are intimately involved, it's much easier to find corporate liability, whereas with a larger company, where the activities are often remote from more central control, it's much more difficult. Now, Article 6, I think it is, of the directive sort of deals with this by requiring that there's a leading person within the company, but it also imposes on the company where the leading person fails to supervise properly. So sort of failure to protect, if you like. And the Law Commission paper is very interesting. It still supports the identification document, but it makes proposals to make it more workable in practice. Now, as I've said, these problems of identification of the will of the company are not required where strict liability offences are involved. The company will simply be liable where the acts are carried out by its employees. Now, I'm not going to sort of go into this now. I have in the recent lecture wondered whether we should now abandon the strict liability concept completely, because I do think there's a danger. It really does devalue the criminal law as such, the stigmatic quality of the criminal law, but we may pick that up in the panel discussion. Anyway, I think what it means is that incorporating strict liability into the EU Directive on Environmental Crime would have been really impossible given the legal traditions in most European countries. But what the directive does do, as in the 2008 directive, is to require intention, or in some cases, at the minimum, serious negligence. All the offences in Article 2.2 incorporate intention, where 3.4 says that some of these offences are also offences where serious negligence is involved. Now, I have to say at first glance, but panelists may enlighten me, I wasn't always clear why some are linked to one category and some the other. And I'd also say that the term gross negligence, which is used in the directive, I think is nearly equivalent. There are articles about this too when we talk about recklessness. Gross negligence is not a term that you normally find in regulatory offences. There was one case quite recently where the judge said it means carelessness, which is really jaw-dropping when you look at it. But I think it's very close to recklessness. My fourth distinctive feature, if you like, of British approaches is whether or not a body such as the Environment Agency decides to initiate a prosecution really remains within their discretion, as it does where public prosecutors are involved. The Crown Prosecution Service, dealing with many ordinary, crimes, not the regulatory offences, requires there to be sufficient evidence to justify a prosecution, but also that a prosecution satisfies the public interest. And there are a number of factors elaborated in their code, which the Environment Agency and others must follow. And to quote from a former Director of Public Prosecutions in 2013, Sir Keir Starmer, prosecutorial discretion is a good thing. It takes the edges off blunt criminal laws. It prevents injustice. Now, public prosecutors in many other European countries don't have such explicit or extensive discretion. Germany, for instance, has long had a principle of compulsory prosecution in the criminal law where there is sufficient evidence to bring the case. Although I suspect in practice, and again, maybe we'll hear from the Prosecutors Network, I think in minor cases that's not often strictly followed. Now, the directive requires the creation of criminal offences for certain breaches of environmental law, but it doesn't deal directly with enforcement discretion. Now, in this country, this degree of discretion given to regulators is tempered by the publication of enforcement policies by the regulators, indicating in what circumstances they are likely to pursue different options. And I am very pro enforcement policies. I think they're very valuable. It helps for consistency and it sends signals to the regulated community that if they do certain things, if they offer, this is likely to be the response. And as far as I can see, the directive doesn't address this issue of enforcement policies explicitly. It does talk about strategies, but I think that's not quite the same thing. And my basic feeling is that I think that all regulators should publish enforcement policies of some sort. And then lastly, until recently, the only sanctions available for most regulators in this country, and this is the big contrast, as Michael pointed out, was in fact a criminal prosecution in the criminal courts, leading to fine or imprisonment, or a caution or a warning. There were very few powers to impose administrative penalties where the regulator doesn't have to go to court. They can impose the penalty direct, generally financial, but with a power to appeal against their imposition. As some of you will know, I conducted a review for the Cabinet Office in 2006 and concluded that across many areas of regulation, not just the environment, food standards, health and safety, the criminal law was being made to do far too much work. And as I said, it's being devalued in the process. And there were offences that were being committed, say, through negligence or even unexpected, but where damage was caused, whether it was to individuals or food poisoning or damage to the environment, or indeed simply non-compliance, the company or the business was saving money, even if they hadn't intended to. A criminal prosecution isn't really justifiable, I don't think, in those circumstances, but you need something more than a warning. So I propose that regulators generally had the power to impose administrative penalties in addition to the criminal law. And legislation in 2008 provided the core framework. And in England, the Environment Agency and Natural England were in fact the first regulators to acquire these powers. Now, as we've heard, administrative penalties are extensively used in countries such as Germany and many other countries. But I think the main difference from the position now in the UK is that in those countries, they are normally imposed by bodies different from the police or the public prosecutors. And they will often relate to distinctive breaches of law rather than criminal offences as such. Here in England and Wales, at least, it's the same body that carries out the prosecuting and imposes the administrative penalties. And it's the same offence which gives rise to both either criminal or administrative sanctions. So the regulator is able to choose the most appropriate sanction in the circumstances of the case, and that should be reflected in the enforcement policy. So in fact, a coordinated approach isn't required as such. It's happening within one body. Now, I think the directive recognises the distinctive position in other European countries in Article 19 by requiring coordinated strategies to, quote, ensuring common priorities and understanding of the relationship between criminal and administrative enforcement. And I think the need for a very coordinated and consistent approach in using these different ranges of sanctions, I think it probably could have been stronger in the directive. And I think other European countries might look, probably not to England and Wales because we've got these single bodies, but look to Scotland, where the criminal prosecutions are carried out in the hands of the Procurator Fiscal, the public prosecutor. Administrative penalties are imposed by SEPA, who also carry out the criminal investigations and will recommend criminal prosecution. And they have a large degree of coordination arrangements. And I think that would be a very good example to look at. But I think there are, and I'm going to sort of really conclude by pointing out two areas in the directive where I think the UK might usefully learn. The first is sentencing. The directive includes provisions for maximum terms of imprisonment of between 5 and 3 years unless death is involved. I think in England and Wales, the 5 years is the normal maximum for criminal offences in the Crown Court, and 6 months in the magistrates, who can refer it to the Crown Court if they want a higher sentence. I was slightly surprised that when it came to fines to individuals, not companies, fines to individuals, the directive doesn't try and specify any figures, but refers in general terms to proportionate fines. With companies, a maximum level is referred to in Article 7, referring to the turnovers of the company. Now, as I mentioned, in England and Wales, unlimited fines are available in both the Crown Court and the magistrates. So these could go far higher, in fact, even than the turnover figures mentioned here. Now, in England, the Sentencing Guidance Council has produced guidelines for environmental offences in 2014 and how fines should be calculated, and indeed imprisonment. And they did have a dramatic effect of increasing the fines overall, especially in the water sector, where millions have been imposed for certain serious offences. Now, I have to say that the term guidelines is slightly misleading, because under Section 59 of the Sentencing Act 2020, a court or judge is obliged to follow the guidelines unless they consider it would be contrary in the interests of justices to do so. Now, when I explained this to a Belgian judge quite recently, he was absolutely outraged. He said this was government and parliament impinging on the independence of the judiciary. Now, I did try to explain that the Sentencing Guidance Council itself has judicial members, but to no avail. So it may be that in the light of those sorts of sensitivities, the directive prescribes the maximum financial sentences, but it doesn't really address the question of guidance or how individual judges should calculate the penalties. On the other hand, that's where the provisions in Article 18 on the training for judges and others could incorporate issues about sentencing, guidance, comparison, and so on, perhaps without being as prescriptive as the British system. Now, Article 7 of the directive lists a whole range of sentencing options, but the obligation is only to include criminal and non-criminal fines. The examples of other forms of sentences, in addition to fines and imprisonment, ranging from obligations to restore to due diligence schemes, they're specified as examples of what may be included rather than obligations. Now, again, I think that may have been a lost opportunity, because it seems to me it's very important to have a great range of options in the criminal courts beyond the rather crude approaches of fines and imprisonment. Now, I think, and Anne will tell me otherwise, I think that most of the options listed in the directive could and can be employed in environmental sentences. For breaches of environmental permitting regulations, courts can order the offender to take remediation steps. Compensation orders can be ordered, although the person who gets the compensation would have to actually own the damaged environment when we're talking about an environmental offence. Disqualification directors can be imposed, and the Environment Agency, of course, can revoke permits. It talks also about exclusion of access to public funding by individuals or companies, where that in this country would basically be done by government if its applicants are thought to be ill-suited. And provisions have been strengthened under the Procurement Act 2023. And there are discretionary powers to exclude applicants, which include where there's been a conviction of an environmental offence likely to cause significant environmental damage. But that decision is not a court order. It's a decision of the government under that legislation. However, there are two options mentioned in the directive which I would like to see pursued in this country. I did recommend both of them in my sanctions review, but they weren't really pursued. The first is publicity orders, mentioned in Article 5, where companies or the individuals convicted of a crime are made to take out advertisements explaining the offence, probably what they're going to do to avoid repeating it, and so on. That's a practice used, I think, with great effect in Canada or Australia. And they're in this country, they're available at the present only in a very limited number of cases, corporate manslaughter and a few other non-environmental offences. But I think they should be made available for all environmental offences. And in fact, the Law Commission in their report 2 years ago recommended that. And for companies, in the directive, the options include the establishment of due diligence schemes. Not quite sure what that means, but I recommended something rather similar for both individuals and companies, where the court would say, in addition to any other sanction, you have to undergo some sort of training to really understand what is the purpose of those regulatory requirements. Now, this would be similar. People in this country would be familiar with this, probably speed awareness courses, which instead of a fine, you have to take a course. And I have to say, having personally undertaken one, I find it far more effective in changing my driving habits. I wasn't a speed merchant, but making me fully aware of the difference between driving just within the limit and just over the limit. I find that a very, very effective way, and I think they could be developed. And then one area not explored explicitly in the directive as an option is the concept of hypothecated fines, where the income from the fines doesn't go to the Treasury, but is used for environmental purposes. Now, every so often that's been proposed for fines for environmental offences, that they should go to the Environment Agency for enforcement. It happens sometimes in local government, and it's just been extended as the IEP report notices for minor fines and waste. I have to say I'm not very comfortable with this approach. I think it can distort your choice of sanctions and enforcement. But generally, I think we could be far more imaginative with sentencing. And in Canada, for example, recent environmental legislation has given the courts extremely wide discretion as the types of sentences they can impose. Almost anything. It's known as creative environmental sentences. And powers have been used to cover most of the examples in the directive. Other examples including ordering sums to be paid for environmental research, funding environmental scholarships, money to go to the Environment Agency to acquire particular equipment, but that's a court order. Now, on two broader matters, and then I will come to a close. Article 17 provides that member states shall ensure sufficient financial resources for bodies involved in investigating, prosecution, environmental crime. Now, in the UK, the question of financial resources would, I think, be considered really entirely a matter of political consideration, except perhaps in very extreme cases. But here it is given quasi-legal status, although whether the Commission would expect this provision to be transposed into national law is another matter. Now, all public bodies, including the Environment Agency and Natural England, have to provide annual accounts to Parliament. But oddly, the provisions in the Environment Act 2021 concerning the annual accounts of the Office for Environmental Protection are the only ones I can think of which require the Office for Environmental Protection of the body to state in the accounts, has the Secretary of State provided it with sufficient funds to carry out its functions? And since the accounts are laid before Parliament, then that becomes a question of political accountability. And there's also very unusually, and I think this is to do with the background of setting up the OEP, there is also a legal duty tucked away in the schedule in the Act on the Secretary of State to fund the OEP to enable it to carry out its functions. But that's very unusual. So I think that's an interesting position. And then finally, I come to the general provisions in Article 22 concerning statistical data. Now, I do worry that the reference to statistical data may imply fairly generalized reports on overall numbers. And I think generally we need far greater published details on individual prosecutions, where impositions of administrative penalties were imposed, and the outcomes in terms of the individual sentencing and so on. And that helps us to understand the effectiveness of the system, to compare and contrast. Now, I think that requirement for transparency and publicity is an issue that applies to both the UK and other European countries. And ironically, perhaps, the level of data published by the European Commission on its own enforcement actions against member states has declined rapidly in recent years. And I'm not quite sure why. It's a retrogressive restraint. Now, in the sanctions report, I had a vision for a sanctioning system which would combine and integrate criminal and administrative sanctions of various types. And that was also set against the principles concerning the purpose of sanctions, principles of transparency, enforcement policies, and core characteristics of the public bodies concerned. Now, I think we've gone some way in this country to achieving this. I'm still working on the vision, and I could do a whole session on that, but I won't. The directive, by focusing on the criminal law, doesn't really address those features of sanctioning, though I think they're hinted at. And these are still going to be challenges for both the UK and the rest of the Europe in the future. Thank you very much.
Thank you very much, Richard, for your valuable insights and your keynote speech. So as such, we are very eager to hear also from our panelists and their reaction to your speech as well. Of course, please stay on, as while we're having our discussion with the panelists, we'll be happy to hear your opinions as well on the topic. First of all, as Michael Rose already introduced me, I'm Chiara Antonelli, Head of Climate and Circular Economy Program at IEEP EU. And from a very foggy Brussels, I would like now to introduce our panelists. So welcome again, Michael Nicholson, who's Head of UK Environmental Policy at IEEP UK. We have Anne Brosnan, Chief Prosecutor of the English Environment Agency. And we have Rob De Rijk, Chair of the European Network of Prosecutors for the Environment. And we finally have Phoebe Clay, Director of Unchecked UK. So as a first round, actually before that, I would like also to invite again our audience to please have a question, include all your questions in the QA box, and we'll be happy to answer as many as possible later on. So as a first question to all panelists, please raise your hand, or whoever wants to go first, is what's your reaction on the keynote speech that Richard has just given? So would you like to pick up any of these bits? Yes, Anne.
Thank you very much, Chiara. Thank you very much to IEP for hosting this webinar, and particularly to Michael for his excellent paper and his introduction. I'm always concerned about speaking after Richard Macrory, because you never know what Richard Macrory is going to say. And he can be very deliberately provocative to try and push the boundaries in terms of environmental law. But I think we're very grateful to Richard for doing that, particularly as his thinking has pretty much led to the administrative, the civil sanctions regime that we have at the present time. I'm going to just spend a couple of minutes just dealing with a couple of points that Richard raised. And the first thing is in relation to prosecutions, that I do think, as Michael has said in his paper, that at the present time, in terms of prosecution, the Environment Agency for England, and I can only speak for the English regulatory system, we will pretty much prosecute anything. We are an equal opportunities prosecutor. The way that the legislation is drafted means that the limitations and the restrictions on operation are there in the legislation. And the legislation is drafted with offence provisions that the Environment Agency can then use to bring offenders and perpetrators to court. So in many cases, environmental crime is linked to the regulatory system, but in some cases we're dealing with wholly illegal activity. And we do have serious and organised crime organisations moving into the arena of environmental offending. We can prosecute everything, and we rely on our enforcement and sanctions policy to direct those cases, those most serious cases, that we'll take forward to prosecution, and we do have to prioritise. The directive says that certain offences should be capable of being dealt with as criminal offences, so the activity must be criminalised, but it doesn't mean that criminal proceedings will actually be instituted. And that's the real test. And that's where I think perhaps we are slightly ahead of other member states in the EU, not all of them, but we are quite prepared and very experienced in bringing forward environmental crime to prosecution. Now, since 2010, we have had an alternative to prosecution. So our foremost approach of bringing cases to court, we now have filled that justice gap with other opportunities to impose sanctions or to accept enforcement undertaking offers. We haven't done that much imposing so far. We haven't used our variable monetary penalties very much. Most of the gap has been filled by offenders coming forward and accepting their liability for some environmental breach or for some pollution incident and seeking to make reparation and to make a payment to a third party that may have been impacted. And that provision for enforcement undertaking has been very successful and has allowed us to divert away from prosecution those cases where it is not necessary in the public interest to prosecute. But there are cases where really we say it is necessary in the public interest to prosecute, where there's serious harm, and we choose in accordance with our enforcement sanctions policy to bring proceedings. We would not encourage private prosecutions. There is a case in the Court of Appeal, the Hart case, which suggests that the Environment Agency is better set up, better established, has more experience and expertise to draw on to bring those private prosecutions. We feel that we are experienced in bringing cases to court as the public body tasked with control of pollution and empowered to bring criminal proceedings. So just to finish on one last point that Richard raised, hypothecated fines. There's a suggestion that has been a water restoration fund established, and there is a suggestion that all fines should go into a hypothecated fund. Richard has said that he's not comfortable with this. I can say that we have some disquiet about hypothecated fines if there is any benefit, direct or indirect, back to the regulator. The system works very well, as in Canada, where there is really good governance around hypothecated fines, where there's clear separation, where there can be no suggestion of monies being used to either come back to the regulator or to replace government funding that would otherwise flow to the regulator for duties. So we have to be careful with those sorts of regimes to make sure they don't undermine the integrity and the independence of the prosecuting authority. But there are models out there that can make it work if government is prepared to put the right governance and separation around it. So those are my initial thoughts, Chiara, and back to you. Thank you very much.
Thank you very much, Anne. I see that there's another reaction from Phoebe. Phoebe, please go ahead.
Thank you so much. And thank you, Anne, because you teed me up very well on the question of funding. It's something that Unchecked UK really focuses on and has very deep concerns about, including the cuts in real terms funding to the Environment Agency, which have been deep and highly political. And this goes back to Professor Macrory's point that these are effectively political decisions that have been made either as a consequence of, a very ideological debate around regulation, a real kind of sense, at least in the UK, that regulations are economically burdensome, that, the role of regulators should be primarily, in some cases, to keep the regulatory burden to to a minimum and get out of the way of economic priorities, including in relation to the environment. So these are really political questions and have led to some very, very stringent financial decisions. The Environment Agency's cuts have been in the region of 47%, Natural England 37%, and there's no real kind of deterrent to that, particularly at the moment where the whole rhetoric around fiscal discipline and prudence is likely to drive further cuts. So whilst I definitely see your concerns around hypothecation, I wonder whether that provides a level of insurance against sort of just an ongoing race to the bottom in terms of the funding that regulators obviously desperately need in order to fulfill their responsibilities, in order to prosecute more, because obviously what we're seeing is a decline in prosecution and inspection regimes as a consequence of cuts. And I guess also in order to restore public trust in what they're doing. It's no surprise that the public is deeply concerned. As Michael said right at the beginning, these are highly emotive questions. People are seeing them in their everyday. People are seeing them affect things that they love deeply, like their local river or their local nature reserve are being kind of eroded as a consequence. So I think just in terms of, the levels of public trust and the levels of public sense that regulators of efficacy, funding is critical. So yes, whilst I totally get the rationale around hypothecation carrying a level of risk, I just wonder whether at this point in proceedings, we really need to take it, as a really sort of serious policy consideration, because otherwise I think the race to the bottom could carry serious risks.
Thank you very much, Phoebe. And after these first reactions, I would like to deep dive a little bit on some specific topics. And with that, I would like now to address a question to Rob on qualified offences. So one of the new elements in this directive is the qualified offence. So this article sharply increases the sentencing levels in the directive, especially for serious and damaging environmental crimes. In your opinion, how significant is this development, and how often do you think it is likely to be applied, given, for instance, resource constraints in different parts of the enforcement chains?
Thank you, Chiara, and thank you, IEEP, for inviting me to speak with you this morning. Firstly, perhaps to introduce myself, I'm more or less in a double capacity here today. I'm, on the one hand, chair of MP, to which I must immediately add that I'm the successor to Anne Brosnan's presidency only from November or so. So in feeling, Anne is still the president, I think, a chair. On the other hand, the system that I know most about, of course, is the Dutch system. And it's easier for me to answer your question, of course, from that position than from the all-over European position. And I would say that this qualified offences provision in the directive does add value to at least the Dutch system, because we are forced to increase penalties and to redefine offences in some of the provisions in the criminal code. So that's a very important impulse for us. I noticed that the preamble of the directive uses the word ecocide-like sort of crime, and that's an important impulse to have a very close look at the provision. What I do expect, on the other hand, as a negative sort of, or perhaps sort of obstacle, would be the burden of proof, which is of course quite a lot for this qualification of an offence. And on the other hand, the word ecocide or ecocide-like raises, as I know, objections from some parts of Europe, where it is said that the word ecocide must not lead to an inflation in the term genocide. I mean, you must be, the word side and the ecocide and genocide raises associations, and you must be careful, it is said, not to inflate the genocide term genocide. So given that, I do think that the provision of Article 3, Section 3 is an important one. It is also an important impulse for the legislators all over Europe to have a closer look at their criminalizations. And it is up to the judges, of course, in the end, and the courts to decide whether or not the standards of this provision are met or not.
Thanks for this consideration, Rob. And this actually gives me also the link to the next question that I would like to address again to Anne. Anne, so Rob has also mentioned penalties, and about this, there's in this new directive a lot more on environmental laws and contravention that could be classed as criminal offenses and obliges member states to treat them as such. So this new directive also sets out the level of penalties for legal and natural persons. These include, for instance, fines of up to 3 to 5% worldwide turnover for companies and imprisonment for several years for individuals. In your opinion, how does this stack up against penalties imposed in England and in the UK?
Thank you, Chiara. That's a very good question. The level of penalties that are included in the directive are very aspirational. So it's really important to think that those penalties that are mentioned in the directive are not the sorts of penalties that are generally being imposed at the moment. And those are high level sanctions that might be imposed in cases. In fact, in most criminal proceedings, penalties at much lower levels are being imposed in relation to the offences that are being brought before the courts. And I think that's the position both across Europe and also in the UK. I'm aware that Ireland have had some big penalties, a €20 million fine for a waste landfill site. We have had significant penalties. I'll come back to our penalties in a moment. But beyond that, I'm not aware of really swinging financial penalties, save I know because we have a good relationship with the US Department of Justice. And I know that they have brought quite significant prosecutions and obtained penalties in relation to emissions from vehicles, the cheat devices that were being used. And I think the US secured a fine of 2.8 billion, which sort of gives you fine envy if you're a prosecutor over here. But we're not really used to imposing that level of, or the courts are not used to imposing that level of fine here. However, that being said, the fines that can be imposed generally in the UK are unlimited. So significant fines can be imposed. The biggest fine that's been imposed in relation to environmental offending was in, I believe, 2021, which was the prosecution of Southern Water Services, where a fine of £90 million was imposed. And it's worth saying for those who are not familiar with cases that when companies are prosecuted, and we prosecute both companies and natural persons, when a company is prosecuted or an individual, they come to court and they plead guilty, they're given a significant discount for that guilty plea because it helps to keep the wheels of the criminal justice system moving. And the starting point for that penalty, the point where the court started, and this case came before a High Court judge who gave a very interesting judgment in relation to it, was £135 million. Now that's by an order of magnitude, a bigger penalty than we have seen in UK courts for environmental offences. The discount for the guilty plea was £45 million, and that should be an encouragement to any company that's charged with environmental offences to consider very carefully whether they wish to challenge them or not. But before that £90 million fine, really the biggest penalty that we'd secured was a fine of 20 million against Thames Water, and it is the water companies who are our biggest and most frequent offenders. So I would say that the possibility is there, the potential is there for big fines, both in the UK and in the EU, but there may be some time to go before big fines are generally being imposed and fines at the right level. And I thought for this webinar that I would print off, we have a data and governance team who keep our statistics. And I asked them, can you just give me the headline figures since 2022? Let's look at what we've done since COVID. So we have a comparator to look at what we're doing in the UK and what may be happening across Europe. So since 2022, I asked for fines against companies which would be in excess of £100,000, because that's just a cut-off point for a big penalty. So we've had 30 fines in excess of £100,000 since 2022, and that's a total of £20 million in the last 3 years. Fines totaling 20,164,000. In that period of time, we've prosecuted 64 individuals. Sorry, we've prosecuted many individuals, 64 of whom have been subject to custodial sentences. And those are immediate sentences of imprisonment or suspended sentences. In that 3-year period, we've had 21 immediate custodial sentences. So the balance of that 64 were suspended sentences. So there's quite significant and frequent levels of sanctioning happening in the criminal courts in England for environmental offences. Now, I just wanted to add on top of that, the enforcement undertakings that we've accepted in that same period, just for the sake of the completeness of the picture. And we've accepted £9 million worth of enforcement undertakings, so about half of what is happening in the courts. So the overall picture is really quite significant: £30 million in fines, 64 individuals where the custody threshold has been passed, and we have had, just for the sake of completeness, about £4 million in orders under proceeds of crime. So I would say that the penalties are quite significant. There's a lot of prosecution activity. Are the penalties big enough? Well, they're not big enough in my book, but then they're never going to be big enough in my book. That's where I come to. I want to make sure, and it's set out in our enforcement sanctions policy, that penalties will punish and deter. And I think we've got to punishment, but I'm not sure that the penalties are yet working as a deterrent. And I think we make this argument to the court, we've made this argument to the Sentencing Council and said, for very large organisation, can we have better guidance for sentencing, for court sentencing large organisations, very large organisations, because we need to make sure there's some more deterrence in the system. So I think that helps just sort of to set the picture of what's happening in the UK. Sorry, in England.
Thank you very much. Thank you, Anne. I see that Michael has his hand raised. So do you have any reaction to Anne's
I
consideration?
do. Thank you, Chiara, and thank you, Anne. I really appreciate that intervention, and I really wanted to come in on that, the sort of the latter part, on the punishment and the deterrence, because you and your team and the Environment Agency and the Crown Prosecution Service, working with Natural England, have done a great job in securing those penalties, those fines and custodial sentences. And when we look to our counterparts, our colleagues over the channel, we can see that those fines are very big. But I think, from looking at it from the outside, that element of, is it dissuasive? Does it deter? Is the really big point. And I think that's the thing that certainly a lot of non-specialists will really question and ask, when you see that particularly large companies have very large turnovers as well as profits, and is it a significant enough of their percentage that they earn in a year or across a 5-year period or across a 10-year period to really make them think to change their way of working, so that they take the environment much more seriously. Just on the first bit that you talked about data and information, and here I just want to shout out how great the Environment Agency and Natural England are at compiling and then publishing information about crimes. And Richard referred to this at the beginning in his keynote speech. So the Environmental Crime Directive 2024 requires the member states to collate and then send in to the European Commission statistical data on environmental crimes. But I think crucially, it doesn't say that it will require the member states to send in information about the cases, not to name the offenders, what the penalties issued are, and so on and so forth, which the Environment Agency and Natural England do, and they publish that information. It's there for everybody to see. You can download the spreadsheets, and there are organizations like ENS, Violation Tracker, who then collate and work their magic and publicize that. Really, this is really where I think the European Union, through its new directive, has maybe missed a little bit of a trick here, and really needs to do more to go in the direction of and take the lead from the Environment Agency and Natural England. So that's what I wanted to say, and I see that Richard has got his hand up as well.
Can I?
Yes, please go ahead.
Yeah, thanks very much. Just on the last point, no, I agree with you about getting the fine detail of the data. Although I knew, and Rob may want to come in, I mean, I know, talking to German colleagues of mine, there are some real problems in Germany privacy law of simply even publishing the name of a company that's been convicted of a crime. I think they can't do it in Germany. So there are, you know, there again, these fundamental issues you suddenly come across. It's quite difficult. But the other thing about the level of fines and being a deterrent, I think quite clearly that, you know, the likelihood of detection being found out is also probably even a bigger deterrent than the amount of the fine. So that's incredibly important. In one area, but it's sort of different from the directive. I'm a great believer, and Anne will know, in the use of AI and satellite data for actually monitoring and detecting crime, because that has its own deterrent effect. You know, it's used for farmers getting grants for CAP, and they have no idea how often the satellite is going over checking the crops. And you could do it for waste site, all sorts of things going on. So I think there's a great, looking at the deterrent effect of being found out is probably as important as the level of fines.
Thank you very much, Richard, for your take. And I see that Rob has a reaction as well. So Rob, please take it forward.
I have to Richard's question about the publication of personal data regarding criminal convictions. We have the same problem, it seems, as the Germans have, and that's privacy regulations on this sort of thing. The exception would be a separate court order in a certain case, but we would not be allowed to publish, say, a series of names of companies or private persons who have been convicted of any criminal offense. So that will be to publish personal data would for us be a problem. Statistical data, of course, are available.
Thank you very much, Rob. And on this, I'd like to hear also from our panelist Phoebe Clay on talking about penalties. And as previous panelists has already said, especially Anne, are penalties big enough? So what do you think about the severity of penalties for environmental crimes in the UK, especially in recent years?
Yeah, so I think our sense is that they're clearly not serving that purpose very effectively. I mean, we focused a lot on water, and it's, you know, striking the fact that these fines have been recurrent, even though these are, you know, big companies with, you know, huge brands with, you know, very eminent boards, you know, and still the behavior has persisted. So certainly looking at the sort of the big players, and I guess one of the benefits of the water scandal in the UK has been that it has put a spotlight on this issue. I think it has also served the purpose of sucking up a lot of the attention, a lot of the public scrutiny, a lot of the media attention. You know, it has become an incredibly, you know, politicized and very high profile issue at the expense, perhaps, and I'd like to sort of caveat this, of other issues, and there are many, I mean, if we begin with wildlife crime, you know, wildlife and countryside links have kind of detected very, very high levels of persistent wildlife crime and very, very low levels of enforcement, and, you know, actually tiny deterrence effects of those enforcement actions. So that's something that obviously for British people is highly, highly emotive, Michael. I think it would go into, you know, the sort of, you know, public scandal, and yet it hasn't actually had that deterrent effect. We've also looked at issues that perhaps feel quite low level, but are incredibly important for our public life. One of them being fly tipping, where we have, you know, fly tippers on the record saying that they view fines as a cost of doing business, right? These fines are so tiny that you just sort of suck them up and get fined again and again and again. And the reason I raise this is that, you know, I think, Richard, you made the point about sort of the small players sometimes being more liable. Well, in those cases, that liability doesn't matter because these are industries that perhaps work below the radar of public scrutiny and don't actually have, you know, the brand factor to actually sort of deter them. You know, they tend to be one-man, two-man shows just doing a lot of harm, right? In a way that people, again, feel very strongly about, right? Fly tipping, if you focus group or if you talk to people on the street, you know, will emerge again and again as one of those environmental issues that people are very, very you know, feel very passionately about. And in a sense, back to my point about undermining public confidence, where I think the regulatory system has a real problem in the UK, people see this as a sort of symptom of a system that is not doing its job, right? And I think that is something that we need to sort of really think about when we're talking about the purpose of regulatory deterrence. You know, people don't see behaviors changing in their day-to-day lives. People will report crimes. People will, you know, make the effort to go to their local authority or to kind of actually sort of take some action online, etc. And still the things continue happening. So yes, I think the deterrence effect isn't strong enough in the UK at sort of multiple levels and across a whole host of issues.
Thanks, Phoebe. Thank you for your take. And with this, I'm very conscious of time, but I would still like to have one question again, and then going back to Anne on non-criminal penalties. So this new directive requires member states to have the ability to apply a range of non-criminal penalties and measures to environmental crimes. For instance, there's the obligation to restore the environment, the withdrawal of permits and authorizations, as well as pay compensation for damage to the environment. So the Environment Agency in England, alongside its counterparts in the UK, have been using non-criminal penalties for quite a long time. Can you tell us about the EA's experience so far?
Yes, I can. We have we have two sorts of penalties. We have our Res Act penalty, the Regulatory and Enforcement and Sanctions Act penalties, which is, if I can call them, Richard's penalties, the ones that came out of the thinking around filling the justice gap between prosecution and caution and then just the warning letter. And then we have some climate change penalties, which are not criminal in nature, where simply financial penalties can be imposed. The climate change penalties tick along very well because they are on they're civil penalties on a civil standard of proof, and quite a number of penalties are imposed, but they don't go near the courts. They're quite low level in terms of the publicity. We simply do publicise the fact that penalties of a certain type have been imposed. The Res Act penalty is much more complicated because these, of course, are an alternative to criminal proceedings, and they're in some ways quite tightly bound up with the decision to prosecute, whether it's necessary in the public interest to bring criminal proceedings. We try to use the civil sanctions, to use the administrative sanctions for lower level offending, and that's something that's been carried over to the Water Special Measures Bill, where automatic penalties and lower standard of proof VMPs are being brought in, but for the more low-level offending. We have, for the reasons that Richard enumerated in his opening speech, had some difficulty imposing VMPs. The methodology we were left with was set by economists in DEFRA, and we couldn't make it work very readily. We couldn't come to the same answer when we tried to calculate the penalty on more than one occasion. So we took the opportunity fairly recently to revise that methodology. We've removed the cap. The government imposed a cap of £250,000, which has been removed. And so we now have power, only since December 2023, to impose variable monetary penalties at an unlimited level. And I think that's an area which is going to be a really important area of growth for us. We haven't been doing a lot of that sanctioning where we directly impose the penalties, but I think that we can and we should, because we have an understanding of the impact, potential environmental impact of some of this environmental offending that we're seeing. And we're not always getting the results that we want from court, and we will take a case, and mentioning no names, we took a company to court for 7 offences over a significant period of time. And it was a company which had previous convictions. And after an awful lot of time, an awful lot of effort, the matter was dealt with by guilty pleas in court, and a fine of £2 million was imposed, which really, in terms of the offending, was insignificant. It really didn't properly reflect the offending that we had seen, that we wanted to bring to book, and the behaviour change that we wanted to bring about. So I think we're going to be looking at VMPs, and they are appealable, they're challengeable to the first tier tribunal. But I think it's an area where we really do want to see more activity taking place. And there's a synergy between what happens in court and what happens with the EUs and the sort of civil sanction penalties. We've had penalties in the millions of pounds. We've had EU offers in the millions of pounds. And I think you'll be seeing variable monetary penalties in future in the millions of pounds. Thank you.